do like to wait to give folks a few minutes to join in. So right around 2:02, I'm going to start talking. So if you've joined us, go ahead and say who you are in the chat, where you're calling in from, and if you're representing an agency, let us know that as well. All right, we have reached 100 participants, which I'm both very excited about and slightly nervous about. So thank you all very much for joining us. I'm going to go ahead and get started because we actually do have a lot of things that I am trying to get through in just an hour. So we are not going to go over the time that we've allotted for this web conference. We're wanting to start on time and end on time. So thank you very, very much for all of you joining. As you can see, folks are continuing to put who they are and where they're calling in from into the chat. And if you are representing an agency, we'd like to know that as well. So before we get started, just a couple of quick reminders on how to use the web conference technology that we're using today, Zoom. The text chat and private chat are both available. We're going to be relying on the text chat, the public text chat heavily to see your comments, your questions, and hopefully the team from Valor that's here will be able to see those questions and answer them, whether they're content related, they're questions about the laws and the legislation that we'll be talking about today, or they're tech support related. We try our best to see every single message just in the chat. I like to say, don't feel shy about messaging us repeatedly because that stuff actually goes really fast. So if you have a question and we haven't gotten to you yet, just send us a private chat. And we're going to introduce ourselves in just a moment. But those private chat messages will go to Julie or to Claudia for tech help. We also have, I'm actually not seeing it, and I don't know if this was if I was supposed to put this in the slide or not. Julie, do we have the raise hand feature available on here for me to call on people and unmute them, or are we just relying on the chat?
That's a good question.
Oh, somebody just raised their hand, so it looks like we have that capability.
Thank you. Oh, yes. I'm like, I know you can do it. I'm just not sure how.
Great. So if folks raise their hand, then we'll be able to know you have a question that way as well. If you're having a problem with the audio, you can always dial in via phone. You will need the phone call-in number and the participation key code that we provide. But if you have any sort of audio problems, just message us into the chat and we'll get it figured out. We also have closed captioning available for this web conference. So if you go down to the bottom of your screen where you see closed caption, and you can enable it that way. And hopefully I don't talk too fast for the captioners. Please forgive me in advance. I know that's a problem I've had before, but I try my best. And at Valor, we really have a strong commitment to accessibility and making sure that everybody can join and participate in our web conferences. So with that, I'm going to go ahead and introduce myself and the team that's here with us today presenting this new laws and legislation web conference. I want to say that in the aftermath of this, we're also going to be sending all of the materials written, and it'll be in a PDF form that you can access to have everything that we're going to talk about and present today, except for the stuff that may come up organically. So if you have any policy issues that have arisen in your community or something, a law that I didn't mention that you think I should have, we will have some time to talk about that as well. And that obviously won't be reflected in what we prepared in advance because we prepared it in advance. So that will be available shortly after this web conference later in the week, and you will get to see that. So my name is John Finley. I am the policy manager for Valor US. I handle all of our statewide and federal public policy work based out of Sacramento. My pronouns are he, him, his. I'm currently actually in San Jose, California, in Santa Clara County. And I know there are a number of folks from Santa Clara County that were on the call. So it's good to see you all. I also want to take this opportunity to introduce someone who we just hired. Her first day was yesterday, and then now today she's on this over 100-person web conference. Kamali Lama. Kamali, are you able to unmute yourself and say hello?
Yes. Hi, everyone. Welcome, and thank you for joining us. My name is Kamali, and like John said, I joined yesterday as a communications and policy associate, and I'll be here supporting our communications and policy projects. Thank you.
Great. Thank you very much. We're very excited to have Kamali with us. For those of you who've joined any of our policy things in the past, you know that I have been a one-person team for some time, and it's very exciting to have somebody help it out with some of our policy work. And those are our emails right there. We'll make sure to go ahead and put those in the chat later as well, so that if anybody has any questions about anything we talked about today, you can follow up with myself or with Kamali. I also want to introduce our tech support team. We have Julie Sina, our event planner, as well. Julie and Claudia, why don't you unmute and introduce yourselves?
Okay, thanks, John. My name's Julie Sena. I am the event planner and project coordinator with Valor. I've been here about 2.5 years, and I'm excited to talk with y'all today.
Hi, everyone. I'm Claudia Cibaja. I use she, her pronouns, and I've been with Valor US almost 2 years. I'm very excited and welcome everybody for being here. And if you have any type of problem, any technical issue, just please feel free to send me a little chat. Thank you.
Fantastic. Thank you both so much for supporting on this web conference. I am like Valor's most notoriously technophobic staffer, so I really appreciate having people help to get this going. So with that, I'm going to go ahead and get started. I will begin with just a couple of policy updates on what's going on at the federal level and what was going on at the state level, separate from all of the legislation that we're going to talk about. And then after I do that, I will actually give a rundown of several sexual assault specific bills that passed or were vetoed in 2021. That we can expect to either take effect into law coming in January 2022, or they may have another effect date within the legislation. That I tried to make sure to make the effect date specific in every single one. As folks may know, we have been in a state of emergency in California since the beginning of the COVID-19 pandemic. And what that means is that legislation that the governor signs can actually take effect immediately upon signature. Normally, it would be assumed that every single piece of legislation that's signed takes effect in January the following year, unless there's another date that's denoted in the legislation. But this year, laws were able to take effect immediately. So it either has a January 1st, 2022 start date, it has a specific start date in the legislation, or it took effect immediately. And we tried to delineate between those. If there's a specific question about whether something is in effect today, I just ask me and I'll follow up on that specific piece of legislation and get back to you. So federal policy. I want to first talk about the VOCA Fix Act. As folks probably remember, we did a significant advocacy push trying to change at the federal level, fix several problems with how the Crime Victims Fund, which is what overwhelmingly supports rape crisis centers and sexual assault programs, but also other crime victim services programs in the state of California. The vast majority of funding for those programs comes from the Crime Victims Fund. And for the past several years, that fund had been declining, really to some pretty scary and unacceptable amounts. And federal legislation to close loopholes in the Victims of Crime Act and to try to get more money out of federal prosecutions that would then go to the Crime Victims Fund. That legislation took a long time, and we worked very hard on it. It ended up passing unanimously through the United States Senate, and then also passed the United States House of Representatives, was signed by President Biden, which is really, really good news that the VOCA situation will not continue getting worse. Some of the bad news is that it takes some time for the federal government to prosecute crime, right? To prosecute white collar crime that would end up with financial assets being deposited into the Crime Victims Fund. And so for this year and next year, there were still some pretty bleak disbursements coming from the Federal Crime Victims Fund. Our response to that in California, which I'll talk about in a bit, was to secure an allocation of $100 million in one-time funding from the state general fund to make sure that there are no cuts in California to federal crime victim services. So rape crisis centers, child advocacy centers, DV programs, anybody receiving VOCA dollars, that's what that allocation was designed to make sure there would be no cuts to. And that was in last year's budget. You heard me talk about it a lot because I worked on it a lot and we wanted to make sure that you knew it happened. So that's that. We are very proud of that advocacy work to prevent any cuts from taking place in California for victim services. Unfortunately, across the country, we know that other states haven't been as fortunate with their budget situations, and other states are taking a look at where they can potentially pull funding to prevent the VOCA situation from impacting them. We have also been prioritizing the reauthorization of the Violence Against Women Act, VAWA, and that process has hit a bit of a stall. So you may recall that last year, the House of Representatives passed a reauthorization of the Violence Against Women Act that included with it several important new protections. Every couple of years, we have always come together on a bipartisan basis to reauthorize VAWA and to update it to include new protections for survivors, include new eligibilities for programs, things that may have been overlooked in the last reauthorization process, try to clean them up next time. It's become a tradition ever since VAWA was passed that this is done, and it's done on a bipartisan basis. But now for several years, VAWA has not technically been authorized at the federal level. The good news is that it doesn't affect the federal appropriations process. We are still able to get funding to programs that are funded via VAWA, via VAWA, I shouldn't have said that are funded through VAWA. We're able to get that funding through the normal congressional appropriations process, even while VAWA remains unauthorized. But our focus on a bipartisan reauthorization of VAWA is still there, and it has still not been introduced in the United States Senate. So all of this is kind of behind the scenes negotiations that are going on, trying to get a bipartisan bill that will pass the United States Senate, much like the VOCA Fix Act did, and will not just be, a Democrat bill. We don't want just a Republican bill. We want a bipartisan reauthorization of the Violence Against Women Act. What we're hearing is that hopefully sometime before the end of this year, there will be an introduction of a reauthorization bill in the United States Senate, that it was kind of following all of these negotiations around the recently passed bipartisan infrastructure bill, as well as what I'm going to talk about in a second, the Biden administration's Build Back Better package and everything going on with that in the House. I want to talk really quickly about the American Rescue Plan, the federal government's massive COVID relief stimulus package that passed earlier in this year, specifically because there is some amount of funding to address community violence included within the Build Back Better plan. Did I say Build Back Better or did I say American Rescue Plan? Let me start with American Rescue Plan. The American Rescue Plan that passed in COVID relief, that includes within it sexual assault specific funding. And in that amount, some of you who are working with DV programs may have seen that there was an amount released from the federal government going to domestic violence programs, specifically to kind of handle any transition or any emergency needs that were the results of us being kind of under the lockdown orders during the pandemic. So programs were transitioning to be virtual, having telehealth services that they had never had before. Those sorts of things. There was funding included in the American Rescue Plan to address that. Now, there was also included within the American Rescue Plan specific funding for sexual assault programs. The domestic violence funding had been released several months ago, and we were still waiting on the sexual assault specific programs. So we do know a great deal more about that funding now, and I explained some of it. We had an executive director's call for rape crisis centers, and I explained some of what's going on with that funding. It is coming to California now. So that'll be to the tune of about $15 million from the federal government to assist rape crisis centers and local sexual assault programs with costs that may be associated with the pandemic. If you have more specific questions about that, we encourage you to reach out to us. It's still in the preliminary process, or the preliminary phase of rolling out that funding. So we don't know very much yet, other than the amount and that it's definitely happening, and we've been waiting for it for some time. So we will get back to you on that, but feel free to talk to us about that incoming funding. And then finally, the Build Back Better plan, which is currently being negotiated in the House of Representatives. I believe it's being negotiated in the Senate as well, although I assume that will happen quite a bit after the House does their negotiations. Included within that is some funding to address community violence and to take a public health approach to addressing community violence. It's a fairly small part of the Build Back Better plan, but it's one that I wanted to point out, that those efforts and grants grants to address community violence through a public health lens, programs in California could be eligible for that next year if the Build Back Better plan passes. And that's something that is currently being discussed. Are there any questions on federal policy before I continue on to the state? All right, I see a raised hand. Go ahead, Nicole. Are you able to unmute yourself? If not, I can do it. Let me do it. Can I do it? I don't know if I can do it. I'm not the whiz kid.
Okay, I think I got it. Can you hear me? Okay, great. I was wondering if you had any information about the status of congressional earmark funding, the community projects that Congress members were able to request that I know were mostly approved through the Appropriations Committee, but I think they're waiting on a bigger spending bill, budget bill to be passed. Do you know what the timing is and if that's even going to happen by the end of the year?
Yeah, so that bigger spending bill is the big Build Back Better plan. That's the massive budget reconciliation, massive spending bill that the House is debating. What I had heard from Speaker Pelosi was that the plan is to hopefully vote on that Build Back Better plan this weekend even. And that's their big priority now that they've passed the bipartisan infrastructure bill, is to pass the Build Back Better plan, and then we'll get into the normal appropriations process leading in December. So
the funding is that funding is included in Build Back Better, or it's going to be after?
It would be
included
after,
in a separate.
I think. Let me make sure to verify that for you, but I'm pretty sure it would be after. And if anybody else knows something else, please put that in the chat.
Thank you.
Of course. All right, I did not see any other questions, so I'm going to move on. A little bit about the state and what's going on here. As I was mentioning, California remains in a state of emergency. And so the emergency powers that were granted to the governor to deal with the COVID-19 pandemic are still ongoing and can still be addressed basically in a fell swoop of a signature from the governor, and lots of things can happen immediately. So that is still the way that things are going. Things are much less slow than they normally would be in California politics due to that. One thing I did want to draw folks' attention to is that last year, in those budget advocacy efforts that I mentioned, I talked about the $100 million in funding for victim services. We also were able to secure one-time funding of $15 million to support prevention of sexual and domestic violence in California, and we're very proud of that. Both of those were really made possible, and our advocacy was focused around the budget surplus that existed last year. And if anybody was listening to either me or the governor or anybody else in fiscal year 2020, we were very worried that it'd be a totally, the governor's words were cataclysmic budget situation leading into the next several years. The absolute opposite has happened. So California had an enormous multi-billion-dollar surplus in fiscal year 21. What I'm hearing is that there's a projected surplus for next year as well. And our advocacy is continuing to make sure that there will be ongoing funding for prevention in California. That's probably our biggest policy priority here in the state, is to stop with these one-time allocations of 5 million here and 15 million there, and hopefully receive just 15 million ongoing in a funded program. So we'll certainly let you know any updates that we receive on that. That is our big focus and has been the topic of several conversations that we've been having. I also wanted to just remind folks that next year is an election year in California. So there will be totally new elections for the state legislature, as well as a gubernatorial election taking place, even though it feels like we just had one, because we did. Gavin Newsom is again up for re-election in November 2022. Before I get into specific bills, were there any general questions about anything I just said in state and federal policy? All right, I'm going to probably go through these much quicker than anybody should. So please bear with me. And if you have any questions, feel free to put those into the chat. There's quite a few of them, and I want to make sure we get to everything. So first, Assembly Bill 46 by Assemblymember Rivas, also known as the California Youth Empowerment Act. It creates a new statewide advisory commission to examine and discuss policy issues affecting the needs, interests, and conditions of the youth of California. That'll begin meeting in August 2022. And the reason that's important is that that commission is specifically charged with making recommendations to the legislature, the state superintendent, and to the governor regarding child sexual abuse. So the existence of that new commission that will have people appointed to it on a statewide basis and begin meeting in August 22. That is something brand new in the state that we have not had before under the California Youth Empowerment Act. And hopefully we'll be able to keep tabs on what happens there, and whatever recommendations that commission is making regarding child sexual abuse, we will keep people aware of and probably contribute to. We look forward to working with that commission in the future and seeing where it goes. Right now, it's just brand new. So that's a new thing for you all to look out for, and perhaps another meeting for people on this call to attend. Assembly Bill 118 by Assemblymember Kamlager, who's now Senator Kamlager, creates the Community Response Initiative to Strengthen Emergency Systems Grant Pilot Program for the purpose of funding community-based alternatives to law enforcement. And that can include campus police as well. I wanted to denote that. And the definition of community-based alternatives that's included in Assembly Bill 118 can include mobile crisis response teams, community paramedicine programs, but it explicitly may not include law enforcement officers or agencies as first responders or co-responders. So the idea behind this is that a certain amount of funding has been set aside, and the grants are supposed to be $250,000 each. They're required to be awarded and begin on January 1st, 2023, and the program is set to end on June 30th, 2026. So this is a 3-year pilot program, which funding has been set aside to create these community-based alternatives to law enforcement response. And it's pretty important to note that law enforcement is kind of explicitly excluded within the legislation from being recipients of the funding. So that has been something that a lot of people had been working on. This pilot program, from what I understand, this 3-year program is really to try out, what these community alternatives to law enforcement can look like. I think we heard that conversation a lot in both academic and activist spaces on the idea of giving people an option other than law enforcement as a first response to nonviolent or violent crime. And I, at this point, know very little about what those projects will end up being in terms of how they practically work. What I do know is that at the outset, these $250K grants are designed to go to people already doing this work in communities who have demonstrated, some kind of promising practice. I don't think these are going to be totally new things as far as I understand it, because the state doesn't generally like to just give out a bunch of money to something they don't know what it is. But that is the new frontier of state funding here, is these community-based alternatives to law enforcement, and they'll be funded by this crises grant pilot program, at least for these first 3 years. I see some comments in the chat. Did I miss anything? can I repeat the impact to campus police forces? Yes. So campus police are just it can include a program on a campus. And so it's all an alternative to the campus police can be included as part of the program. And so if a campus were receiving that funding, which I do believe they would be eligible for, though I'm not positive about that, would have to check in. If a campus were to receive that funding and they were creating a mobile crisis response team, that could not include the campus law enforcement officers in it. But I thought it was important to note that this could be taking place on campuses in California as well. All right, next one. Assembly Bill 124, also ComLogger. It expands current law to provide vacatur relief for people arrested for or convicted of nonviolent offenses that were the direct result of them being a victim of intimate partner violence or sexual violence. And vacatur relief is basically just for those who don't know, is to vacate any charges that you're receiving on that crime that you were charged with because you were a victim of another crime. It also expands the use of an affirmative defense against any charges that the person was coerced to commit as a direct result of being a victim of intimate partner violence or sexual violence. And that bill takes effect on January 1st, 2022. The idea behind this is to make sure that people have the ability, or to make sure that people are not prosecuted for crimes that they committed while as a direct result of being a victim of sexual assault, or they were coerced as a victim of human trafficking or something like that. And this is part of a slew of criminal justice reform bills that came out of the legislature this year. So if there are any questions about that, I can take those as well. But I'm going to keep talking until I see something in the chat, just because I got a lot to get through. Assembly Bill 262, Patterson. This prohibits courts in California from refusing to hear a human trafficking victim's petition for vacatur relief due to the person owing any fines or fees, or to the person's failure to meet any conditions of probation. So a human trafficking victim will still be able to file a petition for vacatur relief, should still get a hearing despite owing any fines or fees to the court or failing to meet conditions of probation. Both of these bills, AB 277 and 611, both make changes to California's Safe at Home program. 277 protects address confidentiality for victims of, the program is protecting address confidentiality for victims of DV, SA, stalking, human trafficking, or elder abuse. And AB 277 expands language access for applicants to that program. And that takes effect January 1st, 2023. And AB 611 updates the program to require any homeowners associations to use the survivor's confidential address. And I wanted to just note that this was drafted and supported by our sister coalition, the California Partnership to End Domestic Violence. Assembly Bill 341, this expands the procedural definition of what constitutes, quote, evidence of sexual conduct by the complaining witness in a rape prosecution, to now include the portions of their social media account that depict any sexual content. And this bill is specifically to make sure that that can't be introduced as evidence. Basically, somebody's social media account where you go and can demonstrate that the survivor was promiscuous or the survivor participated in sexual content. Maybe they were a sex worker themselves, and that evidence from their social media account cannot be introduced into a rape prosecution. So that is now, there was previously a law passed basically to say that evidence of sexual conduct in a rape prosecution can't be introduced. This expands that to include the portions of their social media account. And we contributed to this bill. We didn't end up, we ended up being neutral on it, but we were speaking in the beginning with the author's office about this, and we know the details of this bill, and we're reading it and following it quite extensively. So this is now the law in California. Assembly Bill 453. This is another one that we read. We added our thoughts and added some edits to as well. This is one that has been in the news quite a bit. It expands the civil definition of sexual battery to include the non-consensual removal of a condom during sexual contact. That's known colloquially as stealthing. And this only makes stealthing a civil offense eligible for financial relief. It does not amend or address any criminal codes related to sexual battery. And that's an important distinction. This bill, Assemblymember Garcia had actually been pushing for this bill for some time, and previous versions of it made changes to the criminal code to make stealthing a crime. And this bill actually only includes it in the civil definition of sexual battery. So somebody who is a survivor of stealthing or had that happen to them can file in civil court. And it'll be taken care of that way as opposed to by the criminal justice system. I think the legislature's appetite for introducing new crimes or expanding the definition of crimes pretty much dried up ever since the killing of George Floyd in particular, and the legislature is far more interested in reducing the prison population and reducing the number of crimes than they are in expanding them. And so this was one way to address something that really had nothing on the books addressing it, was going the civil penalty route. And expanding that definition. Now, I do know for a fact a number of other states are looking at drafting their own legislation as it relates to stealthing as a result of California passing this. Is 453 retroactive or only for allegations or incidences occurring after January 1st, 2022? I don't recall there being anything retroactive in the legislation. I believe it takes place for after January 1st. I will confirm that though, because I don't recall after looking at all of these things today. I'll take a look at that, but I'm pretty sure it takes, and actually it may not even be January 1st. It may have been an immediate, because I don't think it had a date included in there. It may have been taking effect immediately, but I will confirm when it takes effect and whether it's retroactive or not. I'll make a note of that. Any other questions about Assembly Bill 453? All right, Assembly Bill 518, WICS. This changes current law that requires a crime that is punishable in different ways by different laws to be punished under the law that provides, this is current law that you currently have to be punished under the law that provides for the longest term of imprisonment. Now you could instead be punished under any of those provisions which the crime is eligible for. So the goal of this legislation would be to reduce required harshness out the gate of California's criminal justice system, and instead allow for some judicial discretion. If your offense is eligible for either this sentence or that sentence, you no longer have to have the maximum term of imprisonment be applied to your case. It could be whichever one the judge deems to be appropriate after you've gone through the full criminal justice process. Assembly Bills Assembly Bill 887 and SB 538, these both increase electronic filing and appearance options for survivors who are seeking a domestic or gun violence restraining order. These were both supported by our sister coalition, the Partnership. And it's really important to note that this now expands the ability of survivors to electronically seek a domestic violence restraining order, which for some time had been an obstacle and a barrier to getting those. And we know a lot of sexual assault survivors also seek DV restraining orders and use those as a means to get whatever accommodations that they may need. So that's important that the electronic filing and electronic appearance options for receiving those restraining orders are now expanded under these bills. Assembly Bill 939, this prohibits a court from ever admitting evidence of the manner in which the victim was dressed during the prosecution of sex crimes. So that's no longer introducible evidence. It no longer has anything to do with a rape prosecution, how a victim was dressed during the sexual assault. That takes effect on January 1st. This is a bill that we supported and helped craft. Oh, I see there was a question in the chat. Did I skip over something? When does 887 go into effect? I believe that one was immediate. I will verify that though. I believe that was an immediate effect one to allow for those electronic filing options basically as soon as they have the capability to provide them. Hopefully that answers your question. I can definitely follow up directly with the Partnership about that because they wrote it. Now, this is one that we supported and helped draft at the beginning, Assembly Bill 1171. This repeals basically all provisions of state law relating to spousal rape. So it makes a number of changes throughout the criminal code because it removes any references to spousal rape as a separate crime from other forms of unlawful sexual intercourse. So that is now punishable as rape if the act would otherwise meet the definition of rape. Necessarily, the bill also would require any person convicted of the crime formally defined as spousal rape to register as a sex offender. And we supported this legislation. I want to talk a little bit about it because historically, or at least for the past 4 or 5 years, Valor has not supported any legislation that adds to criminalization, that expands mandatory minimums, or anything like that. And this bill to us was a little bit different in that it really removes an archaic definition and helps us to understand better what sexual assault is. I mean, the idea of spousal rape, in speaking to most of the district attorneys across the state of California, I didn't even find one who had prosecuted a spousal rape case in the last 10 years. This is really an antiquated way of viewing sexual assault. And now in California, it really follows the idea that rape is rape, regardless of the relationship between the two people, regardless of whether it took place in a marriage or not. And that's the way that the law should be in California. So spousal rape has now been removed from the criminal code and is just punishable as sexual assault. I see a question in the chat. Removes penal code 262. Yeah, it basically changes it. So there's no longer any references to the idea of spousal rape. Any other questions that I missed? I don't think so. Okay, I'm gonna jump ahead here. Is this immediate? Yeah, I believe it was immediate. It didn't have an effect date. There actually, I take that lie back. There were several other bills that were making similar kind of language changes. And it was whichever bill passed first, or excuse me, whichever bill passed last was the one whose changes got to be incorporated into the penal code. So AB 1171 was in fact the bill that was signed last. And so the changes that are included in AB 1171 are the ones that will go into effect. And that, I believe, is supposed to take place January 1st, 2022. Okay, moving along, Assembly Bill 1281 specifies that dismissal of a criminal pleading for a conviction in which the offender had been granted probation or participated as an incarcerated crew member in the California Conservation Camp Program. These are basically incarcerated people who are doing firefighting in California. If their pleading or if they're granted probation or they're participating in that, so their pleading is dismissed, that no longer invalidates a previously issued protective order. And none of those oversight provisions actually don't take effect until July 1st, 2022 as part of the budget process instead of January 1st. So that was important to note. 1455, this revives otherwise time-barred civil claims arising out of a sexual assault committed by a law enforcement officer, and it extends the statute of limitations for filing those claims. Importantly, it eliminates the requirement for victims to, quote, present their claim prior to filing it. That had been a part of basically California civil process of if you're filing a civil claim against a public entity, you have to have presented that claim before filing it, meaning you had to have filed, it could be a personnel report, or it could be, I guess, just an email to a local police department. I'm not really familiar with the presentation process of civil claims, but I do know that this now eliminates that requirement when somebody is a victim of sexual assault committed by law enforcement. There's no longer the requirement to present that claim before filing it in civil court. And Assembly Bill 1540, this makes several changes to criminal procedure related to resentencing, and includes a requirement requiring a presumption for courts to approve a resentencing petition if that recommendation had been made by corrections, by the Board of Parole Hearings, a sheriff, or the sheriff or the prosecuting agency. So in some ways, it takes away a little bit of discretion that courts had in approving resentencing petitions. And now there's the presumption of approval when a resentencing petition or when a resentencing recommendation is made by any of those agencies. Okay, those are all the assembly bills. I apologize for going so fast, but I'm going to keep going fast. Senate Bill 2. This makes sweeping changes to state processes for certifying law enforcement officers, and for the first time creates in California a process for decertifying any officers who have committed various acts of misconduct. This includes sexual harassment and assault. And this was supported by Valor, was supported by the partnership. We gathered the support of multiple domestic violence and sexual assault organizations. Thank you to those of you who signed on to this. I really think that the creation of this process in California was important and overdue. Several other states, and it wasn't just like, blue states or states responding to recent criminal justice reform efforts. California was one of the last states that did not have a process for decertifying officers at the state level who had committed acts of misconduct like this. And so now that process exists. At a separate time, if people have specific questions about Senate Bill 2, I'm happy to go into that in more detail. It's a very lengthy and complicated bill, so I want to make sure to get through this summary before I do that. But please feel free to put any questions you might have into the chat, and I can always get to them later. Senate Bill 24, this is known as Kelly's Law. It'll protect a child's medical information from being shared with a restrained person while that domestic violence restraining order is in place. It would also require certain third parties that provide services to children to adopt additional protocols for protecting it. The point of this is just to make sure that the medical information of a child isn't used and isn't disclosed to somebody who's under a restraining order, to an abuser who's coming to find out more medical information about the child. And this was supported by CPEDV. Senate Bill 92, this was by the Budget Committee, and it's a follow-up to the processes that I had talked about previously, and you may have heard about, of the closing of the Department of Juvenile Justice and reorganization of those facilities into local secure, what are called secure youth treatment facilities. So this includes technical changes that will facilitate the creation of a new independent department within the Health and Human Services Agency in California. It also finally sets a date, June 30th, 2023, as the date for full closure of the State Department of Juvenile Justice, and requires the creation of a transfer plan for any remaining youth under that department's care by January 2nd, 2022. So that I imagine those conversations are ongoing and rapid to plan the closing of the Department of Juvenile Justice. And though that is all supposed to be fully wrapped up by June 30th, 2023. Senate Bill 215 by Connie Leyva. This requires that by July 1st, 2022, the Department of Justice will establish a process that allows sexual assault survivors to track and receive updates privately, securely, and electronically regarding the status, location, or any information pertaining to their sexual assault evidence kit that's in the department's database. And it allows survivors to have access to that data by July 1st, 2022. So now electronically, without going down and filing anything with the police department, a survivor is supposed to be able to receive updates and information about the status of their sexual assault kit and whether it's been tested, where it's been sent, etc. And this will be creating a private, secure electronic mechanism. I have no knowledge of what that mechanism looks like at this time. I know that it has to meet those conditions by July 1st, 2022. So as we get closer to there, we'll know what the Department of Justice is putting together. I see a chat. Hopefully I didn't skip over anything. Will it include results? That's a good question. I don't know whether results will be able to be disclosed over that electronic system. As I understand it, it was designed, and I know this was drafted by Alameda County DA Nancy O'Malley's office, so I can check in with them about that. As I understand it, it was designed so they could get updates on whether it had been tested, not necessarily the results included and transferred over the internet. But I will check in about that. Thank you. Senate Bill 248 requires the CDCR to refer a person directly to the State Department of Hospitals for an evaluation as to whether this person still meets the criteria as a sexually violent predator. If that person is in corrections for an offense committed while they were previously serving an indeterminate term at the state hospital as a sexually violent predator. So this was a very specific loophole in the Sexually Violent Predator Act that, according to the legislation, rewarded an individual who had been committed to a state hospital as a sexually violent predator for then committing a new felony in the hospital to then have an opportunity to relitigate their sexually violent predator status for having committed that new felony. I don't know how often that occurred, but what I do know is that this bill was designed to close that loophole and prevent it from ever occurring again. And now that is the law in California, is that you have an evaluation as to whether that person still meets the criteria as a sexually violent predator, but not an opportunity to relitigate and get that removed. Senate Bill 331 prohibits the use of non-disclosure agreements to settle employment and housing-related legal claims that are involving harassment, discrimination, or retaliation, with limited exceptions when requested by the complainant. I think that's very important, that complainants can kind of still request non-disclosure agreements from harassment cases if they choose, but they can't be forced into entering them by the respondent. The bill also includes the prohibition of terms that would prohibit the separated employee from discussing unlawful conduct at their former workplace unless the separated employee themselves agrees to those terms, and that does take effect January 1st. 352, it establishes that an offense of sexual harassment by a member of the active militia is punishable by specified military proceedings or by a court martial. It requires the California Military Department to report aggregate annual statistics regarding the prevalence of sexual harassment. And it clarifies that crimes, including sex crimes committed while on active duty, are not protected from civil or criminal liability. Senate Bill 374, this was by Senator Rubio. It adds, quote, reproductive coercion as an additional example of coercive control, which disturbs the peace of another and for which a restraining order may be granted under the Domestic Violence Prevention Act. It defines, quote, reproductive coercion as controlling the reproductive autonomy of another through force, threat of force, or intimidation, which may include unreasonably pressuring the other party to become pregnant, deliberately interfering with contraception use or access to reproductive health information, or using coercive tactics to control or attempt to control pregnancy outcomes. Now, I think I had the wrong legislator for this. Thank you, Christine. I see a correction then. This was Senator Min. But yes, that adds reproductive coercion to the definition of coercive control. All right, those are all the bills that were signed that I'm talking about. I'm going to talk very briefly about some that were vetoed or postponed and that could be revisited at some point next year. But I wanted to, these are ones that were kind of important that were getting talked about and where the current status of them is that they're not moving right now, but they could come back. Assembly Bill 307, this was pulled by the author. It would have expanded existing criminal law on revenge porn by removing the requirement that the victim suffer any serious emotional distress, and additionally would have required that the offender register as a sex offender. That was pulled in April. 524, it would have created the Campus Recognized Sorority and Fraternity Transparency Act that would have required campuses to collect and publicize conduct reports for fraternity and sorority members, including citations or disciplinary actions related to sexual assault, and would have required campuses to suspend recognition of any sorority or fraternity that does not comply with the bill's collection requirements. That was pulled from consideration at the request of the author in June, but I know there's a great deal of conversation about fraternities and sororities. Good. Thank you, Christine. I'm so glad you're here. All right, Assembly Bill 892, this failed in committee. It would have required a person convicted of misdemeanor solicitation of a minor for prostitution to register as a sex offender, including with a campus chief of police if the person was residing on the campus. That bill didn't pass a vote of the Assembly Public Safety Committee back in April. I don't know whether there are plans to bring that back or not. But as I was saying, the appetite for expanding crimes and expanding who has to spend time in prison or register as a sex offender, et cetera, that appetite was pretty dried up in 2021. I don't know whether it'll return in 2022, but I wouldn't expect it. Assembly Bill 1456, this went through several changes to the Education Committee. It was vetoed by the governor. This would have made a number of significant reforms to the Cal Grant program. As it relates to sexual assault, it would have required any sexual assault received by a campus security authority receiving Cal Grant funds to be immediately disclosed to law enforcement without identifying the victim unless they consented to being identified. It also would have required that the alleged assailant also not be identified unless they represent an ongoing safety threat, and the immediate assistance of law enforcement is required to contact or detain the assailant. But it was vetoed by the governor for budget reasons. So there was not much, the veto did not address whether, law enforcement should immediately be notified by any campus security authority of any sexual assault taking place. It was strictly due to budget reasons and how much it would cost. And the governor felt that it should be discussed during the budget process as opposed to in the policy process. So I think that one will come back, and whatever changes that are being made to the Cal Grant program, we will stay informed of and engaged with. Our position has for some time been that sexual assault should not necessarily automatically be reported to law enforcement. There may be a number of reasons why a survivor does not want to report for law enforcement, and that choice should be the survivors. That shouldn't be required that they go to law enforcement immediately. That's generally been our position, but when the bill comes back, we will see what it says. 1461, this was also vetoed for budget reasons, so it may come back. It would have provided that applicants who complete their formal application with the appropriate federal agency for a status under VAWA or a special immigrant juvenile status or any asylum status are eligible for certain public social services and healthcare services that are currently authorized to non-citizen survivors of trafficking and serious crimes. And this was vetoed entirely for budget reasons. So I imagine expanding access to eligibility for these programs will come back in the budget process of 2022. This one was stalled in committee. 1467 would require that sexual assault counselors at public colleges and universities be independent from the campus Title IX office. It prohibited sexual assault counselors from notifying the university or any other authority of the victim's identity unless otherwise required, and would require the CSU chancellor to submit orders related to discrimination, harassment, and retaliation in an annual report to the California State Legislature. So this one's been postponed indefinitely as of May. It did not make it off of the Appropriations Committee's suspense file. As you can tell, it's kind of in conflict with the other one that automatically requires things to be reported to law enforcement. If this prohibits counselors from then notifying the university or any other authority of the victim's identity, there would probably be ways for it to work together, but they both did not make it out of committee this past year. So I would imagine some changes will still be lingering to the Title IX process and requiring reporting to whom next year. SB 299, eligibility for compensation under Cal VCP, the Victims Compensation Program, for serious bodily injury or death that was caused by a law enforcement officer's use of force. Regardless of whether that officer is arrested for or charged with or convicted of committing a crime. That passed the Senate, but then was pulled in the Assembly. So it did not get a vote in the Assembly. I don't know whether there's a desire to bring that bill back or not. I know the opposition was pretty stark to that in that if basically anybody who is injured by law enforcement and law enforcement then is not prosecuted with a crime or even charged with a crime for that physical injury that's caused. I mean, this could be the normal course of law enforcement, right? It might be injury is caused on a suspect or on a convicted criminal. Then that person is eligible for victims compensation. And as people know, victims compensation has had a number of problems remaining solvent. And so for budget reasons, as well as for these kind of more substantive policy reasons, this did not make it out of the Assembly. I don't know whether it's coming back, but when it does, I will keep an eye on it. SB 615 would have repealed SB 45 from last year. That exempted certain people who were convicted of sex offenses involving minors if they were not more than 10 years old. I'm sorry, there's a lawnmower, it sounds like. But this bill would have basically repealed that. Fortunately, it was pulled from consideration at the request of the author. I don't think the legislature has any interest in repealing that bill that they worked very hard on. I think we're getting to the end here. This would have required the State Board of Education to adopt a school-wide climate indicator, which would consist of a subset of data from the California Healthy Kids Survey. And so this was being discussed and amended heavily, would require local educational agencies to annually administer that Healthy Kids Survey or an alternative school climate survey. But that first hearing was canceled. So I imagine that'll come back, and it'll come back. I don't know what changes will be made to it, but it will come back. So those are all the laws that we felt were really necessary to let you all know about and talk about. If you have any future ideas, I'm going to name just a couple of things that have been of interest to us really quickly as we conclude here. Number one is that there has been a great deal of interest and conversation about the idea of restorative justice as an alternative to going through the normal criminal justice system. As I understand it, there are currently several references to restorative justice or restorative justice practices in California law, in the education code and elsewhere, saying that restorative justice could be an option for people, but there is not really a definition of what it is. And that's something that we have been looking at, and there's a great deal of conversation about whether there should be a government defined or a government sponsored definition of what is and isn't restorative justice or restorative justice practice. Our concern is that any practice or any group of people would be doing whatever they want and calling it restorative justice. And that could include, mediation, or could include all sorts of things that will not actually help the survivor find healing and find accountability as restorative justice is intended to do. So those are some things that we're thinking about and looking at. We also, I was mentioning our policy priorities around funding and prevention funding in particular. We are still maintaining that should be ongoing and that prevention should always be funded in California. If you have any ideas yourself, or you have anything that I didn't address, or something that's going on that you would like to talk to me about, I will go ahead and put my email in the chat again. And Kamali, if you can put your email in there as well. I wanted to leave you all with this quote from our vice president. If you want to deal with an epidemic, crime, or health, the smartest, most effective, and cheapest way is prevention first. And that's something we really believe here at Valor, and all of the bills you'll find that we want to be involved with and support. I mean, we'll always let you know everything that happens, but you'll find that we want to attach ourselves to things that are focused around preventing sexual assault before it ever happens, and can really change the conditions in society that allow sexual violence to subsist in our communities, and can really eliminate this over the long run. There shouldn't be another generation having to deal with sexual assault ever again. And that is our focus. And I wanted to leave you all with that. You can find us on social media. Our website is valor.us, and I will go ahead and put my email in the chat right now. I hope I did well on time. Okay, great. Because I know I blasted through that. So if there's ever anything you all need, my email is jfinley@valor.us, and I just put it in the chat. All right, that's all I've got. Thank you all very much for joining us. This will be available recorded at some later date. I don't think I have a date, but this will be recorded at some later date. We also will have these materials in PDF form available for you.